Hours 29 minutes 43 seconds remaining. Select to pause. Press left to rewind. Right to fast forward. Press up for player controls. Down for more to watch.
Senators, a couple of points that I'd like to make. Manager Schiff suggested that there was no evidence the president was actually interested in burden sharing because he didn't apparently, according to David Hale, raise it in the telephone conversation that he had with Gordon Sondland that Hale claims to have overheard at a restaurant in Kiev. But let's look at the real evidence. As we explained, on June 24th, there is an email in the record showing, it's an email from one person at the Department of Defense to another with a subject line of POTUS follow-up, President of the United States follow-up, asking specifically about burden sharing. It says, quote, what do other NATO members spend to support Ukraine, end quote. That was what they were following up on for the president. And in the transcript itself, excuse me, in the transcript of the July 25th call itself, the president asked, he said, we spend a lot of effort and a lot of time for Ukraine, much more than the European countries are doing, and they should be helping you more than we are. Germany does almost nothing for you. All they do is talk, and I think it's something you should really ask them about. And he goes on to say that he talks to Angela Merkel about it, and that they're not really doing as much as the United States is doing. He's raising burden sharing, and President Zelensky agreed with him. Now, Manager Schiff also suggested that there is evidence of some connection between the military assistance and investigations into 2016 election interference because of a statement that Acting Chief of Staff Mulvaney made at a press conference. But it's been clear in the record since that press conference that what he was saying was garbled and or misunderstood, and he immediately clarified and said on that day, quote, the president never told me to withhold any money until the Ukrainians did anything related to the server, end quote. And similarly, he issued a statement just the other day, making clear again that he said, this is from his counsel, so it's phrased in the third person. Nor did Mr. Mulvaney ever have a conversation with the president or anyone else indicating that Ukrainian military aid was withheld in exchange for Ukrainian investigation of Burisma, the Bidens, or the 2016 election. That is Mr. Mulvaney's statement. Lastly, on to the point of whether this chamber should hear from Ambassador Bolton. And I think it's important to consider what that means, because it's not just a question of, well, should we just hear one witness? That's not what the real question is going to be. For this institution, the real question is, what is the precedent that is going to be set for what is an acceptable way for the House of Representatives to bring an impeachment of a president of the United States to this chamber? And can it be done in a hurried, half-baked, partisan fashion without, they didn't even subpoena John Bolton below. They didn't even try to get his testimony. And to insist now that this body will become the investigative body, that this body will have to do all the discovery, and that this institution will be effectively paralyzed for months on end because it has to sit as a court of impeachment while now discovery is done, because it would be Ambassador Bolton, and if there are going to be witnesses, then the president would have to, in order, they said fair trial, fair adjudication, then the president would have to have his opportunity to call his witnesses. And there'd be depositions, and this would drag on for months. And then that's the new precedent. Then that's the way all impeachments operate in the future. The House doesn't have to do the work. They do it quick, they throw it over the transom, and this institution gets derailed and has to deal with it. And that should not be the way, that should not be the precedent that is set here for the way this body will have to handle all impeachments in the future, because if it becomes that easy for the House to do it, they'll be doing it a lot. Thank you.
Thank you, Counsel. The senator from Massachusetts.
Send a question to the desk.
Question from Senator Markey to the House managers. On Monday, President Trump tweeted, "The Democrat-controlled House never even asked John Bolton to testify." End quote. So that the record is accurate, did House impeachment investigators ask Mr. Bolton to testify?
Senators, the answer is yes. Of course, we asked John Bolton to testify in the House, and he refused. We asked his deputy, Dr. Kupperman, to testify, and he refused. Fortunately, we asked their deputy, Dr. Fiona Hill, to testify, and she did. We asked her deputy, Colonel Vindman, to testify, and he did. But we did seek the testimony of John Bolton, as well as Dr. Kupperman, and they refused. When we subpoenaed Dr. Kupperman, he sued us, took us to court. When we raised a subpoena with John Bolton's counsel, the same counsel for Dr. Kupperman, the answer was, Senator, you serve us with a subpoena and we will sue you too. We knew, based on the McGahn litigation, it would take months, if not years, to force John Bolton to come and testify. And I should point out, because I think this is an essential point to underscore, as the president's lawyers say, they didn't try hard enough to get John Bolton, or they should have subpoenaed John Bolton. That's what they're telling you. But let me show you what they're telling the court in the McGahn litigation. If we could pull up slide number 39. This is the president's lawyers in court in the McGahn litigation. In the Court of Appeals right now, quote, "The committee," meaning our committee, "lacks Article 3 standing to sue to enforce a congressional subpoena demanding testimony from an individual on matters related to duties as an executive branch official." I mean, it takes your breath away, the duplicity of that argument. They're before you saying they should have tried harder to get these witnesses, they should have subpoenaed, they should have litigated for years, and down the street in the federal courthouse, they're arguing, "Judge, you need to throw them out. They have no standing to sue to force a witness to testify." Are we really prepared to accept that? Now, counsel says, think about the precedent that we would be setting if you allow a House to impeach a president and you permit them to call witnesses. Well, I would submit, think about the precedent you will be setting if you don't allow witnesses in a trial. That, to me, is the much more dangerous precedent here. But I'll tell you there's something even more dangerous, and this was something that we anticipated from the very beginning, which is we understood when we got to this point they could no longer contest the facts that the president withheld military aid from an ally at war to coerce that ally to doing the president's political dirty work. So now they have fallen back on, you shouldn't hear any further evidence, any further witnesses on this subject. What's more, we're going to use the end-all argument, so what? A president is free to abuse their power. We're going to rely on a constitutional theory, a fringe theory, that even the advocate of which says is outside of the consensus of constitutional law, to say that a president can abuse his power with impunity. Now imagine where that leads. A president can abuse his power with impunity. Now, that argument made by Professor Dershowitz is at odds with the Attorney General's own expressed opinion on the subject, with Ken Starr's expressed opinion on the subject, with not only other counsel for the president, Jonathan Turley, who testified in the House, says that theory is constitutional, effectively nonsense. But even 60-year-old Alan Dershowitz doesn't agree with 81-year-old Alan Dershowitz. And for a reason, because where that conclusion leads us is that a president can abuse his power in any kind of way, and there's nothing you can do about it. Now, are we really ready to accept the position that this president or the next can withhold hundreds of millions of dollars of military aid to an ally at war unless they get help in their reelection? Would we say that you could, as president, withhold disaster relief from a governor unless that governor got his attorney general to investigate the president's political rival? That, to me, is the most dangerous argument of all. It's a danger to have a president who engages in misconduct. It's a danger to have a trial with no witnesses and set that precedent. But the biggest danger of all, I think, would be to accept the idea that a president can abuse his office in this way and the Congress is powerless to do anything about it. That is certainly not what the founders intended.
Mr. Chief Justice.
The senator from Tennessee.
Thank you, Mr. Chief Justice. I send a question to the desk on my behalf and also joined by Senators Loeffler, Lee, Kramer, and McSally.
The senators ask of counsel for the president, is the standard for impeachment in the House a lower threshold to meet than the standard for conviction in the Senate? And have the House managers met their evidentiary burden to support a vote of removal?
Mr. Chief Justice, Senators, the standard in the House, of course, the House is not making a final determination in the structure of the Constitution. An impeachment is simply an accusation, and as in most systems where there is simply an accusation being made, the House does not have to adhere to the same standard that is used in the Senate. In most instances, House members have suggested in debates on articles of whether or not to approve articles of impeachment that they should have clear and convincing evidence in the view of the members voting on it that there was some impeachable offense, and that is all. Some not even that standard. And so it is simply enough evidence that an accusation can be made. It is definitely a lower standard than the standard that has to be met here on a trial for an ultimate verdict. The Constitution speaks in terms of a conviction in the Senate. And as both Professor Dershowitz and Judge Starr pointed out in their comments, everywhere in the Constitution that there's any mention of impeachment, it is spoken of in terms of the criminal law. The offenses that define the jurisdiction for the Senate sitting as a court of impeachment are treason, bribery, and high crimes and misdemeanors. The Constitution speaks of a conviction upon being convicted in the Senate. It speaks of all crimes being tried by a jury except in cases of impeachment, again suggesting notions of the criminal law. And as we pointed out in our trial memorandum, all of these textual references make it clear that the standards of the criminal law should apply in the trial, certainly to the extent of the burden and standard of proof to be carried by the House managers, which means proof beyond a reasonable doubt. And it is very clear that there is not any requirement for proof beyond a reasonable doubt simply for the House to vote upon articles of impeachment. There's a very much higher standard at stake here. As we pointed out in our trial memorandum, the mere accusation made by the House comes here with no presumption of regularity at all in its favor. The Senate sits as trier of both fact and law, reviewing both factual and legal issues de novo, and the House managers are held to a standard of proving proof beyond a reasonable doubt of every element of what would be a cognizable, impeachable offense. Here, they have failed in their burden of proof. They've also failed on the law. They have not stated in the articles of impeachment anything that on its face amounts to an impeachable offense. And on the facts, I think we have demonstrated very clearly